310, service on a partnership. Personal service upon persons conducting business as a partnership may be made by either personally serving the summons on one of them or delivering it to the managing/general agent or person in charge of the partnership's office within the state. And mailing by first-class mail the summons to the partner at his last known residential address or the place of business of the partnership. Or nail and mail. Nailing must be done at the actual place of business, but the mailing can be done to his last known residence or the office of the partnership within the state. This also has the 20-20-10 rule. 310-A, service on a limited partnership. You could personally deliver the summons to the managing/general agent, a general partner, any person designated by appointment for the purpose of receiving process in the manner provided by law for services of a summons, as if such person was a defendant, or pursuant to the partnership law, or if service is impracticable under sub A, make an order to show cause and the court can direct the manner of service. 310, this is a long one. Service upon a corporation or government subdivision. 1. Service on a domestic or foreign corporation. You could serve an officer, director, managing/general agent, cashier or assistant cashier, or any agent authorized by law or appointment to receive service, or pursuant to 306 or 307 of the BCL. If impracticable, you can make a motion. You can make an order to show cause, and the court can tell you how to serve the corporation. 2. To serve New York City, serve the Corporation Council. 3. To serve any other city, mayor, comptroller, treasurer, council, or city clerk. 4. County, you serve the county chair, the clerk of the board of supervisors, the county attorney, or the county treasurer. 5. For a town, you serve the town supervisor or town clerk. 6. Village, mayor, village clerk, or any trustee. 7. School district, upon a school officer, which is defined in the education law. 8. Park, sewage, or district. You could serve the clerk, trustee, or a member of the board. Oh, and that thing I just did was 311. 311-A, personal service upon LLCs, so limited liability companies. A, service of process on any domestic or foreign LLC shall be made by delivering a copy personally to I, any member of the LLC in this state, I. If the management of the LLC is vested in its members, I. Any manager of the LLC company in this state, if the management of the LLC is vested in one or more of the managers, I. To any other agent authorized by appointment or by law for service of a summons, as if such person was a defendant. Service of process upon an LLC may also be made pursuant to Article 3 of the LLC law. B, if service is impracticable under sub A, it may be made, so basically also you can make an order to show cause and the court will tell you how to effectuate service on the limited liability company. 312, personal service upon a court, board, or commission. So a court with 3 or more judges, you could serve the summons on any one of them, but you have to deliver the summons to one of them. Personal service on a board or commission having a chairman or other presiding officer, secretary, or clerk, or by whatever official title he is known, may be made by delivering the summons to him. Personal service upon a board or commission. Personal service upon a board or commission of a town or village may also be made by delivering the summons to the clerk of the town or village. Personal service upon any other board or commission shall be made by delivering the summons to any one of its members. 312-A, personal service by mail. This is when you mail the person a statement by mail. And this is like for lawyers who sue each other all the time or whatever. They have so this is 312-A, personal service by mail. And in order for this to work, there has to be an acknowledgement of service signed. And the acknowledgement of service has to be in this form. So when you send somebody the summons by mail, you also have to send them by first-class mail, postage prepaid, a copy of summons and complaint or summons and notice or notice of petition, together with 2 copies of a statement of service by mail and acknowledgement of receipt in the form set forth in sub D, which is what I just showed you on the, what I just showed on the video. With a return envelope, postage prepaid, addressed to the sender. B, completion of service in time for answer. The defendant, an authorized employee, his lawyer, or an employee of the defendant's attorney must complete the acknowledgement of receipt within 30 days from the date of receipt. 30 days from the date of receipt. Service is complete on the date the signed acknowledgement of receipt is mailed or delivered to the sender. The signed acknowledgement of receipt shall constitute proof of service. 2, where a complaint or petition is served with the summons and notice of petition, the defendant shall serve an answer within 20 days. Whoa. Okay, let me start over with that. Where the complaint or petition is served with the summons or notice of petition, the defendant shall serve an answer within 20 days of when he mailed the acknowledgement of receipt. C, affirmation. Acknowledgement of receipt of service shall be subscribed and affirmed as true under penalties of perjury and shall have the same force and effect as an affidavit. D, statement of service by mail shall be substantially in the following form. And then that's the whole thing, and it basically says, you know, you should keep a copy for your records. If you do not complete and return the form to the sender within 30 days, you or the party on behalf that you are being served will be required to pay expenses incurred in serving you, and the cost of such service as permitted by law will be entered as a judgment against you. If you have received the complaint or petition with this statement, you have 20 days to answer. You are served on behalf of a corporation. You must indicate under your signature your relationship to the entity. If you are served on behalf of another person, you must indicate under your signature your authority. It is a crime to forge a signature or make a false entry on this statement or on the acknowledgement. And then it has the acknowledgement here where it's got the military service thing. Okay, so when a duly executed acknowledgement is not returned, upon the subsequent service of process in another manner permitted by law, the summons or notice of petition or paper served with the summons shall indicate that an attempt was previously made to effect service pursuant to this section. F, disbursements. When it's not returned within 30 days, the reasonable expense shall be taxed by the court on notice pursuant to 8402 of this chapter as a disbursement to the party serving process, and the court shall direct immediate judgment in that amount. .313, service without the state giving personal jurisdiction. A person domiciled in a state or subject to the jurisdiction of the courts or as executor or administrator may be served with the summons without the state by any person authorized to make service within the state who is a resident of the state, or by a person authorized to make service by the laws of the state, territory, possession, or country in which service is made, or by any duly qualified attorney, solicitor, barrister, or equivalent in such jurisdiction. So this is only applicable if you're subject to the jurisdiction of the courts under Cplr 301 or 302. 314, service without the state not giving personal jurisdiction in certain actions. Service may be made without the state by any person authorized by section 313 in the same manner as service is made within the state. 1, in a matrimonial action. 2, where a judgment is demanded that the person to be served be excluded from a vested or contingent interest in lien or in, okay. God, this is a weird one. I don't even remember reading this. Service without the state not giving personal jurisdiction in certain actions. Service may be made without the state by a person authorized by 313 in the same manner as service is made within the state. 1, in a matrimonial action. 2, where judgment is demanded that the person to be served be excluded from some interest in real or personal property within the state, or that such an interest or lien in favor of either party be enforced, regulated, defined, or limited, or otherwise affecting the title of such property, including an action of interpleader or defensive interpleader. I don't really know what that means, but I'll just try to remember that there's something about that, and it's lumped in with a matrimonial action. And 3, where a levy upon property of the person to be served has been made within the state pursuant to an order of attachment, or a chattel of such person has been seized in an action to recover a chattel. I'm a little confused by that, but I'm gonna have to ask for help on that one, I think, because I don't really get 3:14. 3:15, service by publication authorized. The court, if you make an order to show cause, so upon motion without notice, shall order service of a summons by publication if service cannot be made by another prescribed method with due diligence. 3:16, service by publication. Filing. An order for a service of a summons by publication shall direct that the summons be published together with the notice to defendant, a brief statement of the nature of the action and the relief sought, and accepted an action for medical malpractice, the sum of money for which judgment may be taken in case of default. And if the action is brought to recover title or possession or use of or enjoyment of real property, a brief description of the property in 2 papers, at least 1 in English, designated in the order as most likely to give notice to the person to be served for a specified time, at least once in each of 4 consecutive weeks, except that in a matrimonial, 1 English newspaper is okay and you only have to do it for 3 weeks. That shall be sufficient. The summons complaint or summons with a notice in an action for divorce or separation, order and papers on which the order was based shall be filed on or before the first day of publication. B. Mailing to accompany publication in matrimonials. The order for the service by publication shall also direct that on or before the first day of publication, a copy of the summons be mailed to the person to be served, unless a place where the person would probably receive mail cannot with due diligence be ascertained, and the court dispenses with such mailing. A notice of publication shall be enclosed. C. Time of publication when service is complete. The first publication has to be made within 30 days after the order is granted. Service is complete on the 28th day, unless it's a matrimonial 21st day. 3:17.